to go ahead and get started with introductions, and as you join in, we'll catch in. But my name is Elizabeth Risen. I am the marketing and events director at the Texas Chiropractic Association. I want to thank each and every one of you for spending your lunch hour with us, because this is such an important topic that we wanted to get out. Our speaker today is Dr. Massingill. He is a principal attorney at Massingill Attorneys and Counselors at Law, a full-service law firm in Austin, Texas. He leads a team of 7 practicing attorneys in various fields of healthcare, business law, construction, civil litigation, and estate planning. As an attorney and lobbyist for the Texas Chiropractic Association, he is widely recognized as being knowledgeable about legal issues facing Texas chiropractors. In 2017, he assisted in drafting SB 679, a landmark bill authorizing chiropractors to jointly own medical entities with physicians and help guide that bill to passage. He routinely manages 7- and 8-figure corporate transactions for domestic and international clients in various industries. His previous clients include various elected officials, members of Texas Health Licensing Boards, and a former Surgeon General of the United States. Help me in welcoming Josh to this webinar. Welcome.
Thanks. Thank you. Thanks for that introduction. Good afternoon, everybody. Thanks for being here. The date that you've probably had circled on your calendars for weeks now has arrived. The excitement is palpable. I can feel it. You're all excited to learn about this federal legislation that will be affecting your business. Look, I know this could potentially be sort of a dull topic, but it is important. So my goal today is just to get you in and out quickly, teach you what you need to know, and hopefully you find that helpful. Let me get the presentation started here.
And just to note, we do have the Q&A. So if you do want to leave a question, once Josh has finished, we will get to those, as many as we can with time providing.
Yeah, looking forward to that. So I have to begin with some disclaimers. You know, attorneys, we love disclaimers. I'll just tell you quickly that this is legal education, not legal advice. I can't give you advice unless I knew more about your specific situation. And I'm an attorney. I'm not your attorney just because you watched this webinar. So with that out of the way, we'll get going. The agenda is pretty simple. I'm going to give you an overview of the Corporate Transparency Act. We're going to answer some key questions, just the important things that you need to know, teach you how to comply, and then give you some practical advice. And then we'll have time for some questions at the end. So the Corporate Transparency Act, what is it? This is something that was passed by Congress back in 2021. It had actually been in the works for several years, began in, I think, 2019, was enacted in 2021, and now took effect January 1 of this year. And it caught a lot of people by surprise. So it's the kind of thing that's been sort of in the works for a while, but people weren't paying a lot of attention until just recently. And you may have even gotten a notice this week or recently from your CPA about this. So people are beginning to kind of pay attention. So you're going to be on the leading edge of understanding what this act is and what it means. It's a piece of legislation that requires businesses to submit beneficial ownership information reports, or BOI reports, to the U.S. Department of Treasury's Financial Crimes Enforcement Network, or FinCEN. So it's going to require businesses to report information about their beneficial owners to FinCEN. That's what this act does. Primarily, it affects small businesses. And that's one of the things that makes it unique, because much of federal regulation is aimed at big business, but this affects small businesses and probably affects most chiropractic clinics here in the state of Texas. Entities formed in 2024, so this year, are going to have 90 days to comply, 90 days after formation to comply. Eventually, that's going to be trimmed down to 30 days to comply. But if your entity was formed before this year, most of yours probably were, I would assume, you have until the end of the year to comply. So you've got some time before this is something that you need to worry too much about, but wanted to go ahead and make you aware of everything so that you could begin this process when you're ready. And of course, just like paying your taxes or complying with, other types of federal regulations, there are hefty penalties for non-compliance. So this is something that, like it or not, it's probably going to affect you. You need to learn how to comply. So major questions that we're going to answer today, hopefully. First of all, why does the law require this? Like, why did Congress inflict this on us? What is a beneficial owner? Like, who does that even apply to? What information are we going to have to report about these people to the government? When am I going to have to do it? Who is required to do it? And is it possible that I might be exempt from having to file? And then once I give the government all this information, like, who's going to have access to it? And then if I need to begrudgingly comply, how do I go about doing that? So those are kind of the burning questions, and we're going to answer those today pretty efficiently. So why did Congress do this to us? Well, why does the law even require this? 27,104,006, according to a recent study. That's the number of small businesses in the US that have 0 employees. So these are holding companies or single member LLCs, or maybe like husband-wife LLCs, tiny companies in the US that don't have employees. And this has been a real blind spot for government and regulators and for law enforcement, because large companies have to file all kinds of reports and publish all sorts of information about themselves, and that's visible to the government. But these smaller companies, and particularly the ones that have 0 employees, that's a real black hole for the government. And that's really what this bill, this piece of legislation, was aimed at. Most sophisticated criminal enterprises are carried out by way of business entities. The mob, they don't do business as a sole proprietorship. They've got holding companies and shell companies. This is how criminal enterprises tend to work. And it's difficult for the government to trace those entities back to the humans behind them, who own and operate them. And so Congress just decided, that the federal government needed more tools, better tools to combat illicit activity like tax fraud, money laundering, financing terrorism. So that's ostensibly why the bill was passed. It's why it's been enacted, and it's why you're going to have to comply with it. So who is a beneficial owner? If I've got to report information about my, company's beneficial owners, like, who does that even apply to? And as you might imagine, it's just not quite as simple as it should be. Beneficial owner is a confusing legal term of art that applies even to people who aren't actual owners of the business. So it's got owners in the title, but we're talking about a category of people that includes more than people who just own equity in a business. So it is confusing. It specifically applies to people who either directly or indirectly exercise substantial control over the reporting company or own at least 25% of the equity. And the key word that you want to pay attention to there is or. So you don't have to own equity and exercise control. Either of those things would make you a beneficial owner of a company, exercising substantial control over it or owning at least 25% of the equity. So let's dig into this just a little bit more and kind of teach you how to do this analysis. Substantial control. What does that mean when we say substantial control? Now, the government made us this beautiful chart, which just has all the pizzazz that you would expect from FinCEN. And it attempts to sort of explain what this term means. And basically it covers senior officers. So your president, your vice president, your CEO, COO, C anything O, those are going to be covered with substantial control. Anyone who has appointment or removal authority of those kinds of officers, so anybody who can appoint or remove an officer, that counts as substantial control. And then you've got these two kind of broad categories of important decision makers and anyone who exercises significant influence over the company. And when you think about it, those are incredibly broad terms. Like, these categories are extremely inclusive. And, as a result, I can think of all sorts of examples of people who, you probably don't think of them as an owner or part owner of your company, but they probably are going to qualify and therefore need to be included in your company's BOI reporting. Examples might include key employees without an official title. So maybe you've just got a front office person or like an office manager that, they don't have a big fancy title, but they're sort of acting as a de facto officer of your corporation. They're signing checks and making some decisions. That probably is someone who meets the threshold for substantial control and would need to be included in your reporting. Office managers, spouses, doesn't matter that, your husband or wife, their name may not be on the paperwork, but if they're exercising substantial control, they probably are a beneficial owner under this act. And then, of course, like parents of minor shareholders. So there's all these people who you're not going to commonly sort of think of as being an owner of your company, who fit into this category of being a beneficial owner because of the control that they assert over the company, not because of anything that they own or don't own. And then, of course, even the concept of ownership interest is more complicated than it should be. I mean, what is ownership interest? Again, we've got another handy kind of chart here. And it includes, obviously, like equity holders. So that's people who own stock or shares of a company, regardless of the class or the series or voting rights or anything like that. Anybody who actually owns equity in your company. And you got to be careful because equity can be expressed differently depending on the type of entity that you have. So if you have a corporation, it's expressed as shares or stock. If you have an LLC or a PLLC, it's commonly expressed in terms of membership. So units of membership or a percentage of membership interest. So the terminology, there's a lot of flexibility there, but any actual ownership in a company, obviously that counts. It also includes incentive unit holders who are participating in profit sharing plans. So like, some companies don't, they give profit sharing to employees and it kind of feels like equity. It's actually not legally an ownership interest in the company. It's just sort of what the IRS calls a profit interest. And when you see those legal documents, they're often labeled as, incentive awards or incentive unit awards. But that, under this act, qualifies as ownership and would subject you to BOI reporting. Even like holders of a convertible note. And I know this is sort of less common, but we do see these even in the chiropractic world where somebody, loans money to the company and the company sort of has an option. They can either pay it back or one or both of the parties can agree to convert that debt into equity at a later date. So whether or not you actually intend to do that, if that's an option, then just holding that debt, that counts as ownership interest under the Corporate Transparency Act. And then holders of options to buy or sell equity interests, the company has to report that unless they're not aware, right? So if you had a company who, let's say they had 5 owners and one of the owners secretly grants an option to, buy shares to, a friend of theirs, and the company doesn't know about it. If the company doesn't know about it, they don't have to report it. But anybody who has an option to buy or sell, that is going to include them in this as well. And even, like private lenders, so not like banks, banks and most financial institutions are going to be exempted from reporting. And we'll talk a little bit later about some of the other exemptions. But like private parties who have loaned money to a company and secured that loan with the assets of the company. So they have a security interest in the assets or the shares of the company. That theoretically could subject them to BOI reporting. So it's just a little more complex than you might initially think when you see that term ownership. We're talking about a broad group of people that could qualify and would need to be included in your company's reporting. Again, what you're going to want to pay attention to is this catch-all category because it does most of the work here. Now, once you figure out, kind of who qualifies, the question is, well, okay, what information do we need to report? What does the government need from you? So it's sort of bifurcated depending on when your entity was formed. So if you had a pre-existing entity that existed before this year, then really all you have to report is information about the company's beneficial owners. So some, identifying information about the specific people who meet those qualifications we talked about earlier. If, however, the entity was formed after January 1 of this year, so in 2024, the companies are going to have to report information about their beneficial owners and information about what's called their company applicants, which basically is going to be the lawyer or paralegal who assisted in forming the entity. So, our law firm does 500 or 600 of these a year, and my name's going to be on them. Our paralegal's name is going to be on these reports. It's a pretty extensive reporting requirement, but you don't have to do that if your entity existed prior to this year. That's just this year and moving forward. Now, when do we have to do this, right? Like if we're going to comply, how long do we have to report this information? And again, it's kind of bifurcated because if your entity existed before this year, you have till the end of the year to comply. And it's possible that might even be extended to the end of 2025. So I don't know, Congress is weird, but it's possible that can be extended, but you've got a little bit of time before you have to deal with this if your company existed before January 1 of this year. But if you have a new entity, you got to comply within 90 days of formation. And it was supposed to be 30. They extended it to 90 because everything was kind of a mess. People were kind of getting their footing. Beginning next year, so 2025 and beyond, just going to be 30 days. So you'll have 30 days to comply after the entity is formed. Now, let's talk about updates. What happens if some of the information that you report is accurate at the time you report it and then later changes? Because, some companies with multiple owners, they got people buying and selling all the time. You've got employees that you're hiring and firing. And so the people who are exercising control of your company can change from time to time. So that it's just this ongoing thing. And the answer is anytime there's a change to previously reported information, you're going to have to report that to FinCEN within 30 days after the change occurs. And I just want to pause here and reiterate that, because when people think about reporting requirements, they tend to think about, annual reports. Once a year, I've got to do this. This is not a once a year thing. This is at the, initial formation, or for older companies, by the end of this year. And then from then on, anytime information changes that you've reported, you got 30 calendar days to report it to FinCEN, or you're going to face hefty penalties. So reporting companies, you're going to have to file updated reports anytime information changes. This is going to be an ongoing obligation that you're going to face. So just a helpful tip here to file away for later when you get ready to do this. Each beneficial owner, so each human owner of your company or key employee, what you're going to want to do is have them get their own FinCEN ID number. And the reason we want them to obtain their own FinCEN ID is so that when they move, or when their personal information changes, so it's not information about the company, but it's information about that specific person. When that changes, they can report it to FinCEN. That becomes their obligation, not the company's obligation. And this is especially important for companies where you've got multiple owners, 3, 4, 5, 6 or more, people who own part of the company. You do not want the company having to file an updated report every time a member moves or whatever. So you're going to want each beneficial owner to get their own FinCEN ID so that they can handle that reporting about their personal information. So who needs to file? Like, who does this cover? What types of companies are going to be hit by this? And again, this is where it gets sticky, because most federal business regulation is aimed at large companies. And just to give you some examples, FMLA, the Affordable Care Act, the Worker Adjustment and Retraining Notification Act, EEOC regulations. All of these things are, you probably heard about them, but chances are you haven't had to actually comply with them because they only cover companies that have, 50 or more employees within a 75-mile radius for FMLA, or 50 or more employees for ACA, or 15 or more for EEOC. But this legislation, this law is aimed directly at small businesses. So you're not being caught up in this accidentally. This is aimed squarely at you, and it's something you're going to need to comply with. So who needs to file? They break it down according to domestic reporting companies and these foreign reporting companies. So for domestic companies, we're talking about corporations or LLCs, LLPs, PAs, PCs. There's any type of entity legally that you create by filing a document with the Secretary of State or similar office, that is a domestic reporting company. And when we talk about filing a document, in Texas, we call that a certificate of formation. Other states call that, articles of incorporation. There's different names for it, but any legal entity that gets formed that way is considered a domestic reporting company. But then you've also got foreign reporting companies, and these are companies that are formed, let's say in Europe or elsewhere, and they were not established here, they were not chartered in the US, but they are registered to do business here. So they filed a registration, as a foreign entity with the state of Texas or any other, jurisdiction in the US. Those are considered foreign reporting companies. So these are who needs to file. Some business trusts are also going to be required to file. And there's some other, kind of weird, categories that aren't broadly applicable, but generally, any type of entity. So not a sole prop, not if you're just doing business under your own name or whatever, but anybody who has a legal entity is going to be required to file. Now, who doesn't need to file? Are there any types of entities or businesses that might be exempt from filing? And the answer is yes. There's 23 exemptions, and each of them has a series of tests and factors that have to be considered to figure out whether you fit into it. Most of these are just not broadly applicable. They're not anything that you're going to need to worry about because you're not a credit union, you're not a bank, you're not an insurance company. But there are a couple that might be more sort of broadly applicable, and I want to call those to your attention here. Tax exempt entities. So if you've got a nonprofit, you're probably not going to have to report. If you're a large operating company, that would be an exemption category that might apply to some of you. So to fit into that exemption, you have to have annual gross receipts over 5 million reported to the IRS. So some of you that have larger clinics, you're probably going to fit into that category, that exemption. And then you've got, subsidiaries of any of these exempt entities. So if you've got an entity that's exempt because they fall into one of these categories, then their subsidiaries are also going to be exempt. And then there's this other exemption for inactive entities. And again, it's a little more complicated than this, but basically what we're looking at there are entities that were formed prior to 2020. Why? I don't know, but it's 2020. Before 2020 and right now aren't doing any business. They're just totally inactive. So some of those inactive entities aren't going to need to file. So the bottom line is for you guys, unless you fit into that large operating company category, this is going to apply to you, and it's something you're going to have to deal with. So once you report all this information, like who's going to have access to it, right? That was the big question on everybody's mind. And the official answer is that BOI information will be stored in a secure, non-public database. And rest assured, it's safe. Hopefully, this database isn't maintained by the same government agency that failed to prevent China's unauthorized access to my federal employment file and my SF-86 for my top secret clearance. That hopefully whoever is maintaining this database does a little bit better job. So color me skeptical, but this information is intended to be secure and private and accessible only by people who have sort of a good reason to get at it for law enforcement type purposes. So, we're talking about federal, state, local officials, some foreign officials who submit a request to a US government agency, so like international information sharing for national security purposes. And then in some cases, financial institutions will have access to this information with your consent. So a reporting company can consent to allow financial institutions to access this information. So the database of info isn't going to be publicly available, in theory, publicly searchable. So it should still be possible to kind of maintain a certain amount of privacy, with the broader public. But in terms of government, I mean, they're going to have access to all this, and these are the rules about, who can access this. So how do you comply? Since you're probably going to be covered by this act, that's the big question. Like, what do I need to do? What's the takeaway? You basically have two options. You can hire a lawyer, or you can do it yourself. And those really are the options: hire a lawyer or do it yourself. I would strongly advise you to steer clear of LegalZoom and these other kind of robo lawyers, the DIY options out there, for a couple of reasons. Filing a BOI report isn't exceptionally difficult. What's difficult is the legal analysis. And I think you've gotten a taste of that in the presentation today. You're trying to figure out, well, who does this really cover, and does this person qualify? So the analysis is what's difficult. The filing of the report is actually pretty straightforward. And because these robo lawyers can't perform the analysis, they don't really provide any value. I mean, their websites are no better or easier to use than FinCEN's. So it doesn't make sense, in my opinion, to pay LegalZoom, $200 to take your information that you put on their form, and then they put it on the government form for you. There's not a lot of value there. And that isn't always the case. So like for trademarks, sometimes, things like that, we'll send people to LegalZoom because that, the federal trademark website is an absolute beast. It's just a total nightmare. But FinCEN's website for this is actually pretty decent. So really not going to get a lot of value out of paying LegalZoom or somebody like that. So you either need to do this yourself, or if you have questions about who, am I exempt, or who really applies here, you're going to want to hire a lawyer. So if you were going to file the report, you just go to FinCEN's website. It's fincen.gov/BOI, and it's for government. It's actually a fairly decent website. You're just going to click right there on file a report. Or right underneath it, you can see it says, create a FinCEN ID. That's what you do if you wanted the members of your company or the shareholders to go ahead and get their own FinCEN ID, and then you would use that ID number in the company's reporting. But to file that report, you just click right there and get on it. They've got a lot of helpful information and some FAQs up on the website. I encourage you to look at that, but that's how you would do it if you're going to do it yourself. If you're going to hire a lawyer, don't worry about it. But if you want to do it yourself, this is how it would work. So just some other kind of takeaways, tidbits. CPAs probably can't help you with this. The big four accounting firms have taken the position, along with some of the national sort of associations of accountants, that this is not something that CPAs should do. They think it qualifies as legal work, mainly because the IRS isn't involved. The IRS has no, sort of function in no application here. So CPAs can't really do this without most likely violating the unauthorized practice of law rules in most jurisdictions. So don't expect your accountant to be chomping at the bit to help you with this. Attorneys who form business entities for clients are probably going to insist on handling the initial reporting obligation themselves. Reason being, the only alternative is sort of divulging sensitive information about themselves and their paralegals and stuff to you, which they're not going to want to do. And they're also not going to want to take liability for your potential reporting errors. So when you form a new entity with a lawyer or whatever, they're probably going to want to do this initial report themselves, and then change reports, updated reports. That's a different story. That's something you might be able to handle on your own. And then because of that, you could probably expect entity formation services to get a little bit more expensive. So the bottom line, is that the Corporate Transparency Act is the law of the land, and it probably applies to you. You're going to have to comply, or you're going to face penalties. And if you don't want your company's, if you don't want to do it yourself, hire a lawyer is what I would say. So I know that's been kind of a whirlwind, but happy to take any questions if there are questions. And so let's just see here if we can.
Okay, I don't see any yet in the Q&A, but if anyone has some questions, please feel free to go ahead and put those in and we can help answer those. Great information, Josh. Very informative. Thank you.
Yeah, thanks.
Oh, we have one question.
Yeah, so great question about what sort of information is going to be requested. Like, is it name and address? It is name and address. It is more than that, because what they really want to do is verify your identity. So you're going to have to upload some verification that you are who you say you are. So that might be a passport, could be a driver's license. So it's quite a bit of information. It's more than just like telling them your name and address. Unfortunately, it's a little bit more involved. Have another question here about what happens when I retire? Do I have to report when I retire? So I guess it depends on what you mean by retire. So if the company is going to be wound up and go out of business, then obviously, that would end its obligation to continue reporting. But if the company is going to continue to exist, then whether or not you're actively practicing doesn't really matter, as long as you qualify as a beneficial owner, either because of your ownership or because of the control that you exercise over the company. You're going to need to continue reporting. Had another question here about the FinCEN ID. Yeah, so that's a unique identifier that you can get. You don't necessarily have to get it, but I recommend that members of the company do. And the FinCEN ID is sort of a unique personal identifier that is linked to you. So kind of like a social security number, but different, just for you. And it's going to include, your name and address and all of the other information they glean about you through verifying your identity, like with a passport or something. So had a question here from Dr. Harrison. He thinks he's probably the only beneficial owner in the company. Do you still recommend that you create an ID or just file the report? If it's a single member company, and if you're confident that nobody else in your company, would exercise enough control to kind of be squeezed into that category of beneficial owner, then you probably can just file the company's report, because if you move, you're going to have to update the FinCEN ID, for you personally, or just update it on behalf of the company. And it's kind of tomato, but definitely in a multi-member context or a company that has more than one shareholder, I think it makes a lot more sense to have the individual shareholder, create their own FinCEN ID. Another question here about, like if you've got multiple corporations in multiple states, that gets complex. And so certainly, like anybody who fits into that kind of category where you've got sort of the Russian nesting dolls of companies inside of companies, and a PLLC that's the general partner in a limited partnership, which is owned by a corporate, any kind of thing like that, you're definitely not going to want to attempt this on your own. That analysis can get really complicated. You're going to want to use an attorney. And this is something that we're going to be helping people with. So if people wanted to reach out, we'd be happy to help you. But any attorney probably who does business work would be qualified to do this. Again, your CPA is probably not going to be a great option. Another question about FinCEN ID, only updating it if you move. I guess, that's that's sort of the main example of what would require you to update that FinCEN ID is moving. I suppose there are other things that you could do that would require you to update it. For example, like if you were to change your name legally, so like if you get married and you change your last name, something like that probably would require it to be updated. But the key really is just any time information that has been reported gets submitted, to FinCEN. If that information changes, you're going to have to update either your personal FinCEN ID info or the company's information. Had somebody asking about the specific government website address. Yeah, that was on there. Let me pull that back up here. Maybe I can enter that in the chat, but it's just fincen.gov. So it's FINCEN.gov/BOI. And you can also pull that up. If you Google it, it's probably the first thing that shows up. And again, just make sure that you're on the actual government website and not one of these third-party kind of companies, because again, I don't think there's a lot of value there. If you're going to do it yourself, you can probably do it for free. Don't need to pay somebody to transfer your information. Let's see here. Any other questions?
It looks like the chat questions have been answered. Thank you. And then on the webinar chat, you did put in that website for that question as well. So far we are up to date on both chat and Q&A.
Good. Well, yeah, I appreciate everybody being here. I think it's good that you are paying attention to this. Like I said, this week, actually, a lot of people got a notice, sort of a standard notice from their accountant about this. And so people have been freaking out. And again, this is kind of catching up with people. It's catching people by surprise. So this is something that you're going to be hearing more about over the course of this year, and is going to be a major concern for a lot of folks. And so I think it's good that you're kind of out in front of it like this. Probably makes sense to go ahead and try to comply, make sure you get it in by the deadline. But again, if you have any questions, I just encourage you to reach out to an attorney, because the analysis can be a little bit complicated. It's not your average kind of just reporting obligation. So if you have questions, you're going to want to probably find counsel.
Great. Thank you so much, Josh, for the information. And thank you to all of our attendees today. Looks like that's all the questions. So thank you for your time today.
Yeah, thank you very much. I appreciate it.
All right. Everybody have a wonderful day. Thank you so much.
You too. Thanks.
Bye.